Hi guys, it's Kathy. I have a special best of the mess today. A little longer than my normal ones, but it's so good. A Karen duo, mother-daughter, gets sued by their attorney. There's a lot of arguing and fighting and denial and delusion going on. Get ready for delusional people. Here we go.
Okay, let's hear from the plaintiff first.
Yes, good afternoon. Good afternoon. I am simply here with two small claims actions for payment of legal fees. I was retained by Haley Goodwin and her mother, Ramona Pintek. The retainer agreement is dated May 25, 2022. It was in regard to a child custody action for her youngest daughter. The retainer agreement is attached to my small claims action. It shows in there a retainer of $5,000 with then monthly statements sent to them to show my services. My hourly rate is $250. That's spelled out in the retainer agreement as well. The current balance is over $10,000 that hasn't been paid. You'll see communications from, I think mostly Ms. Pintek. There was never the monthly statements went to them. There was never any challenge of the monthly statements. It was more, they were working on coming up with payment to pay me. And there's an acknowledgement of that in those communications that were attached. So I am asking the court for payment or a judgment, against Haley Goodwin in the amount of $5,349.82 with the added expenses of my costs, which are $104.82 in that case. And then since we're doing them both at the same time, Your Honor, with respect to Ms. Pintek, who also signed the retainer agreement, you will see that I'm seeking $5,349.82 against her, as well as the fees for that matter of, again, $104.82.
Okay, anything further from the plaintiff?
No, Your Honor.
Okay, well, let's hear from the defendants. Who wishes to go first?
I will, if that's okay. I'm the mother.
Okay, so you are Ms. Pintek? I'm
Miss Ramona Pintek, yes.
Okay.
I'm the mother of Haley and the grandmother to Mila, who the case was over. I'm sorry.
Okay. You may proceed.
We retained Megan Belden on May 25th, like she said, in 2022, with the understanding that she was going to be able to accomplish some things for us. I asked her straight out if she would be willing to fight for my daughter, and she said, yes, I will. I asked three simple things when we first paid her. And by the way, Your Honor, by the time she started questioning the $10,000, she had already received $12,000 from us, okay? So she was paid right along with a lot of money. And I asked her if she could find out where the opposing person was living, where the granddaughter was going, the girl that was living with her. And my granddaughter mentioned that the child of this girl also had the mental issues, and we wanted to get that information. Nothing was accomplished till November when they went before the mediator to settle one of the court orders, okay? Nothing was accomplished. All we got was paperwork, meetings, putting off any violation. I mean, just dealing with everything. David was at this point, the opposing party at this point was violating all the court orders. So in November, the court orders were set again. Okay.
So nothing was accomplished, but you had mediation and meetings. Okay, gotcha.
She had through the time that we had her from May 25th to March 31st of 2023. That's 10 months. There was no violations and no motions ever filed against the opposing party to keep this whole situation under control with the granddaughter. Now, she states that what she filed here on line 9. The reasons for the claims: the defendant retained my services to help her daughter keep custody of her young daughter, which is my granddaughter. Okay. This morning, we just came out of a 3.5-hour mediation because of her negligence of not filing any court orders to keep the opposing party in line. He now has seeks emergency custody and has had my granddaughter now for 2.5 months, trying to get full custody.
Yes, because I see lawyers give custody away all the time because another lawyer didn't file a motion.
And Barry, the same complaints he had when we were working with Megan, who never filed anything against him in order to keep this under control. Had she done her job, we wouldn't be in this position today. So now we're in dire straits with another $10,000 debt from her. All we've received is $12,000 worth of paperwork. And now we've had to come up with more money for a new lawyer. So this is where we're at this time, Your Honor. And through the course, we asked, we demanded, we were frustrated to have her file these things. She had witnesses. She refused to go to trial. She refused to file anything for us in our favor. I do believe there has been severe negligence and her legal malpractice. She did not represent us very well. In December, she gave us a conversation, December of 2022. So from May till December, she called me up the 22nd of December and was reminding me of this little debt that was starting to occur, although she had already received $12,000. And that I brought up the two issues to her about David still not complying his court orders from June and November. And she said she was going to put a motion in. She wanted to have this debt paid off by the end of the year. She knew I had a certain amount of money I had to save for my taxes. She knew where I stood financially. And yet she continued to charge us for all these charges. And absolutely nothing was done. So December, she said she would put it in. I followed up in January. She informed me that she did not put the motion in because of our debt. She, at that point, sent our case over to her secretary, Lynn, who took care of things till March 31st when it was dragged on and nothing was done. Again, I texted her March 31st, the month of March, and said, I do want you to file this before the school year ends because we're going to have hell all through the summer because he doesn't file court orders. Okay, she had to have an extra $20.60 to file a motion because David still hadn't filed his court orders. She took the money and nothing was done. We received no support from her for any motions or violations against the opposing party from the time she agreed to take this on to the time she recused herself. And she still wants $10,000 more. And now we're in more dire straits because of her negligence. No, I'm sorry. My daughter would like to speak.
No, I'm just saying.
Throughout the course, when we would ask her to file a motion, she would say, well, I'm afraid if we do this, then they'll come back with that. Well, I'm afraid if we file this, then they'll come back with that. It was always hemming and hawing, and I would say, who cares? You're the opposing lawyer. Let's get it done. Well, I'm afraid. Let's just wait a little longer. You know, Haley has these drug charges, which she didn't have any drug charges. She was testing negative on everything. We didn't get any support on that. And basically, she just him and hawed all the way through it. Nothing was settled. Nothing was done. And there's where we stand. Would you like to add anything?
Okay, let's hear from the other defendant, Ms. Goodwin.
I think she pretty much said it all. I mean, Megan told me a few times that the only reason she took this case was because she thought it was going to be open closed. I was going to go to rehab. And that was not the case at all. We had a very strong case, and the other side was just false accusations. And now I'm in an even serious situation because she never filed what she was supposed to file. And now I have not have custody of my daughter. So when she says the office helped me keep my daughter, it's not true because I do not have her now because of the things that she refused to do for me.
Over and over, she refused to do what we asked.
Okay, anything further from the defendants? Okay, well, let's hear back from the plaintiff then.
Yeah, yes, Your Honor. If you see the attached statements for my services, this was a very active file, a very full-time file for me. The defendants came to me desperate There was an active CPS case going on. Miss Goodwin had, the children had missed such a tremendous amount of school. The tardies in missed school were above and beyond. I don't have the numbers in front of me, but it was a lot. There were also positive drug tests. There were accusations of negligence with kids running around unsupervised. I took this case after, with Ms. Pintek pleading. They had tried to meet with other attorneys and other attorneys refused. But by no means was this a passive file. I had at no time made a statement to Ms. Goodwin that I thought this was going to be an open and closed case. Actually, I told both parties at the onset that I thought there was a drug issue when I first read through all the pleadings, and I was going to try to assist them in kind of a come to Jesus moment. They insisted that there was no drug issue. Haley agreed to drug test. She was diligent in that drug testing, but there was a lot of monitoring that was required with that drug testing. It was random drug testing of, I believe, 2 times a week. There was a lot of monitoring with respect to that. We went to mediation. We had multiple hearings. We had multiple stipulations reached. The end goal was reached. Haley had her daughter back when she was on the brink of losing her. Since my involvement in the case, I did see that there was another motion filed, and I received something from Ms. Slauger, who represents the dad, who I understand that there was something filed because of, I don't know if it was a positive drug test. I know it was missed school. I know there was the pleadings at least stated that there was missed school, there was re-enrollment at another school, there was refusal or not handing over the child for parenting time. There was a lack of cooperation or follow through with the agreement by Ms. Goodwin based on the pleadings. Again, I can't tell you what the history was. There had been a breakdown in communication with my client at that point where I would correspond with them and not hear back. But again, if you go through I would wholeheartedly disagree with their assessment in my involvement in this matter. If you go through the statements, that this complaint has only come up since the point in time when I was asking them to allow me to withdraw as counsel because of failure to make payment. They found another attorney. They wouldn't cooperate with signing withdrawal counsel. I was able to get Mr. Shirley, who's new with Newman Law Group. I asked him when I saw that he had filed to enter an appearance. I simply said, will you agree to my withdrawal as counsel at this point? And he signed off on that. And so I am out as being involved in this case, but I would say this was a very involved file. I at no point took my legal services and handed off to my assistant to do my legal work. I work hand in hand with my legal assistant, in day-to-day matters, but she at no point was managing the file on her own.
Okay, let me ask you a question. At the outset of your representation, who had custody of the child? I guess who had physical custody, I assume, of the child?
And again, I don't have the custody file in front of me. My recollection is that at the time of when they came to me, they had not seen their granddaughter. She had been kept from them for the entire summer. She had not had parenting. Miss Goodwin had not had parenting time for the entire summer, and Mr. Walston was stating he was going to continue to keep her unless there were some safeguards put in place. So I came in, there had already been pleadings filed. I got involved to respond to that. We went in front of referee Hagan, and an agreement was reached that if Haley would, Miss Goodwin would cooperate with regular drug testing, a commitment to have the kids at school timely, not have the kids miss school, that they would allow the custody arrangement. Miss Goodwin had primary custody. Mr. Walston had every other weekend, that they would let that continue, and they wouldn't proceed with their case of Mr. Walston pushing for full custody of of the daughter Mila. Mr. Walston lives out of town. I believe he lives by Boyne City. So probably joint custody with the daughter or with the child that's in school full time would be hard to exercise for these parties.
Okay. So let me ask the defendants, when Ms. Belden started representing you in this custody matter, is it true that you did not have any custody, and you actually, it sounds like you didn't have any visitation? So
No, I had full custody.
Yeah.
He stole her.
He kidnapped her.
He parentally kidnapped her for 10 weeks.
Yes.
Without any willingness. He wasn't allowed to do that. He did it, and we had to go to court because he took her. He only had every other weekend.
Okay.
I had primary custody.
He parentally kidnapped. We filed the paperwork. So the courts did nothing. So then when we went to court, go ahead with the motion at that time.
What?
Then when we went to court, it started with Megan. Yep. Haley was to do it. They tried to push drug stuff. It was not true. And Megan never did stand behind her on that. She always put that up in front of our face like that was always an issue when it wasn't. My daughter doesn't do drugs. But when somebody doesn't believe in you, what do you do? So anyway, she agreed to it just to prove them wrong. Okay, she had the CPS case opened up on her, and the CPS case was closed because there was no substance to withstand it. Therefore, the CPS case was dropped. And when we got a hold of Megan, it wasn't because everybody else refused. It's because they came off 2020. They were so backed up booked, they couldn't take the case on. She's the only one that had an opening. That's the only reason why we took her. Okay, no one else refused. So we're going to stand there. And Haley wasn't on the brink of losing her daughter. Haley was on the brink of having her daughter kidnapped, and we were trying to prove him wrong. So she went ahead and did the drug testings. She proved negative. She had one come up, and it was only because the girl that was representing her for the CPS was David's best friend, one of his best friends, who should have recused herself. And they were tampered with. So Haley refused to go through her anymore, and she started going a new direction on her own. And ever since then, they were all negative. The girl has since been fired. We had two witnesses from the Lana. What were their names?
Yeah.
CPS Lana was the counselor and the overseer.
Mm-hmm.
That both said there was no substance to it. That's why they closed it. And yet Megan still didn't stand behind her on this. She kept throwing it in her face like she couldn't do this and we couldn't do that because they're going to bring back with this. She never, if you notice, Your Honor, she never filed one thing against him. So he was supposed to set up with Safe Haven every Wednesday. Okay, so that we didn't have to deal with his vile and vulgar behavior, which is written in our court order. And he was set up in November to start doing that. Okay, he never did. He drove by once a week, sometimes twice a week, and never got set up with Safe Haven. We had a spot held because it's very hard to get in there. We had a spot held, and for 2.5 months, he drove by, never would answer their calls, refused to show up on his appointments, and Megan did absolutely nothing because we needed to get him accountable for his behavior through somebody. So she would not file anything on that. So therefore it got blown off. He refused and nothing happened. He also was supposed to be paying twice a week on her P-test. He was supposed to be paying 1/2 of that every week. He drove by it every week, never did anything. Every so many weeks, he would all of a sudden just throw a check at her, not even knowing what it was. He was supposed to do it every week. She never filed anything on that either. So he got away with that too. You know, she's always afraid that if she filed something, they were going to come against us with something else. I personally do not think she was equipped to take this on. I think she should have been honest from the start. If she thought she was overwhelmed, we had conversation upon conversation with her about having things filed. She refused, but we got charged for all these conversations, all these meetings, all these phone calls. Nothing was done. She got $12,000 and nothing was accomplished. And now we're in more dire straits than we were before. And she wants another $10,000 when nothing was done. Absolutely nothing. Haley followed through on everything. Haley was proven negative.
Okay, let me ask the question.
Sure.
At the time that you hired her, your daughter was not getting any visitation at all. Is that correct?
No, she had full
I
custody.
had full custody of her.
She had full custody of her. He was trying to give false accusations and take her away because when they went to in November, he was only paying $98 a month in child support. And when he filed that in November, they decided to make him start paying $700 some a month. I'm sorry, I'm yelling. I'm used to dealing with people that are deaf because I deal with in-home caregiving for the elderly. So I'm always used to yelling. So please forgive me. I'm not yelling.
That's okay. That's okay.
I'm conditioned after 16, 20 years. So,
no problem.
Yeah, so he kidnapped her, took her to court, tried to prove Haley had drugs, and it was all dropped. Haley had full custody. That thank God we're able to hang on to that. But because of the fact that she was derelict in her duty on doing the rest of the filing of the orders, he has now come back with the same complaints and even more dire than it was before because she did not follow through on anything. It was just all we have is $12,000 worth of paperwork. That's it. Nothing was accomplished.
Okay. I'm going to take a moment to look through the documents, and then I'll get back to you. Okay, I'm
Sure.
right here. I just want to look through them a little.
Yeah, nothing. I'm sorry.
Your Honor, if I could clarify one point, there was the order in place at the time that I got involved showed that Ms. Goodwin had primary custody of Mila, but she had not had her child for, I think I'll let her, I think it was 10 or 12 weeks, 10 weeks, that she had not seen her daughter. So she had not exercised, she had not been able to have parenting time during that time because the co-parent was keeping the daughter from her with no visits because there was an active CPS case because Ms. Goodwin had tested positive with drug tests. I know Ms. Goodwin and Ms. Pintek refute the accuracy of those test results, but there were positive drug test results. There were notices of improper supervision of the children. There was concerns about the number of missed school and unexcused absence and tardies. Tardies not being 10 minutes, but hours that were putting the children behind. That's what I came in on the eve of, was trying to get her daughter back. It was right before the start of this. It was right before this. We were trying. The time was of the essence to get her daughter back to her. But when you look through my timesheets, you will see there were a lot of documents filed. There was a lot of work done on this. It was not me listening to things and not being serious. There was a positive drug test. Well, this matter was going on. There was a positive drug test. There was a missed drug test while this matter was pending. All of these were things that created issues that we had to troubleshoot through because the agreement that the parties stipulated to stated that, that there would be no missed drug tests, that there would be no positive drug tests, or else Mila would be back with dad for a period of days until Ms. Goodwin could show X number of drug tests showing that she was clean of any substance abuse before she would get her time back with her daughter.
Okay.
Would like to say something if we could.
Okay. If you just give me a moment, I'm trying to.
Sure.
Who represented the father?
Amy
Amy
Swager. Yes.
Mm-hmm.
And she has for a long time. She's been involved in that file well before me. Ms. Walston had another attorney before me.
Yep, third attorney. She's on her third one.
Yeah, I reviewed that. Anything further from the defendants?
Yes, she brought up the positive test that was in the CPS case that she was not involved with. And as you understand, if you listen to what we were just talking about, everything she brought up was negative. There was no positive behind any of this. It was always fear. We better not. I'm not going to. We can't. As you can see, there was nothing filed. Had she filed against David, he would have been accountable to Safe Haven, and we would eventually had it on weekends too, where we wouldn't have had to be dealing with his vile and his vulgar behavior and his aggressiveness. Okay, we have suffered all summer long with him not going to the place of exchange and doing it on his own terms because he had nobody filing a court order that he violated. and we didn't have any more money. We gave her everything we had, and she knew what my finances were. She knew I only had so much money, and yet she continued to charge us for looking at a simple 10-second negative test, $50. And she says she gave us a break afterwards, but there's been overcharges throughout this whole thing with phone calls and such, Laura. I don't have it all in front of me at this moment because we just came off a 3.5 hour mediation, and I apologize for that. It's been overwhelming. All this could have been avoided had she done her job. Okay? And she wasn't on the brink of losing her daughter. She had full custody, and we would remain full custody had she done what she needed to do. Okay, Your Honor, it was not overwhelming. It was not overbearing. She wasn't overwhelmed. She just didn't follow through on anything. Paperwork did not help us at all.
Okay. Anything from Ms. Goodwin? Anything further from Ms. Goodwin?
I think that about sums it up. I mean, I trusted her, and I trusted her to help me with things that I couldn't do myself, and I feel like she failed me. And she did not file anything against my opposing party, my ex-husband, that could have helped me where I am now. And it would have helped me tremendously had he had violations filed against him and motions filed against him. But now I have nothing because it was never done.
She refused to do it. We could have even had a court trial where we could have proved that there were allegations of drugs was not even warranted because he didn't get the child afterwards because it wasn't warranted. There was nothing sustaining it, but she never would look through the goodness. She'd always focus on, oh, we've got all these charges. Oh, we got all this. No, we don't. So it was failed. She got $12,000. And at that point, I still believe she was overpaid at that point.
Okay, then back to the plaintiff. Anything further from the plaintiff?
Your Honor, I would just state if you look at the court docket, you will see how active this file is. I was brought in on my responsive pleading was filed on May 27th. There was a hearing, a one-day hearing on on the plaintiff's motion for change of custody on June 13th. Or June 13th, was that the date? I asked for an adjournment. The court wouldn't give me that. I'm sorry, June 13th. There was a lot of prep work getting ready for a full day hearing on that matter for June 13th. We submitted trial brief, exhibits. I talked to all the witnesses. There was an active child protective services case. There were positive drug tests. There was a failure to submit the kids, get the kids to school. There was an excessive, for some reason, 100 sticks in my head of either late tardies or parties.
Excuse me. We'll just hear from one party at a time. Thank you.
I'm sorry, sir.
We continued on. There was a settlement conference on October 10th, 2022. There was a continuation of hearing for November 4th. This has been an extensive, very involved matter. I got involved in the matter. They came to me needing a responsive pleading to the plaintiff's pending motion regarding custody. There was never an analysis of them filing a motion for custody. It was responding and refuting everything in the defendant's custody motion for change of custody because Ms. Goodwin already had under the order primary custody of her daughter. The plaintiff only had every other weekend, and we were trying to keep that. We were trying to maintain that. I firmly believe that the current situation that the defendant is in is due to her violation of following the agreements that were put in place. It's not due to anything that I did. It's rather a failure to execute the agreed upon terms.
Your Honor, when you get a chance, will I be able to speak again?
In a moment.
Okay, thank you, sir.
Anything additional from Ms. Pentak? And please don't repeat anything, okay? Because I've heard it. It doesn't do any good hearing twice.
Okay. The CPS case that Megan Belden is referring to was dropped in August of 2022, before the school year, when she continued to help us maintain Haley's full custody. Still at that point, again, nothing was taken care of when school year was ended in 2023. So the CPS case was dropped. There wasn't no fear of that at all. Okay? There was no substance.
Okay.
Okay.
Your Honor, I would agree with that. As a reminder, though, I got involved in this case in May of 2022. So when CPS case was closed in August of 2022, it was several months later and after there was an agreement between the parties on how to, they had an agreement by that point on how to execute parenting time and some parameters for safeguards that they agreed to.
So let me ask the defendants a question. Prior to the lawsuit, did you ever object to any billings that were sent to you?
At that time, we were just trusting her with what she was doing. We didn't know anything about what her paperwork was involved. I mean, she put down that this was going on, and you know, we had emails when we questioned it and asked her for a breakdown of a bill because we didn't understand how it was so high. I mean, she had already gotten 12,000, and there's multiple emails saying, you know, something's not right here, and asking for the breakdown of the whole entire bill. And during the breakdown, we did see that there were some irregularities, quite a few irregularities. So we were very confused about it. I tried to set up an appointment with her in January. I only had a little bit of time because I had 2 clients at the time. And we had an appointment set up, and then she canceled on me and said she was going to be busy for the next 3 weeks in January, which really put me in a pickle because then I was really, you know, desperate for, okay, we really need to get this taken care of. She tried to justify everything, but like I said it before, Your Honor, and I know you don't want to hear repeat again, if she had filed anything against this, we wouldn't be where we are today. I know.
I've heard that.
It's just still happens. We still don't know why.
Okay, thank you.
Yeah, Your Honor, they did make subsequent payments since there was not a challenge of my bill. I always timely met with the parties. I don't recall a 3-week cancellation. I know Ms. Pintek had to cancel multiple appointments that she set up with me because of different things going on with childcare arrangements. But this is new to me that I'm hearing that I was ever unresponsive to them. That would be the last thing I would have thought they would have claimed here.
Okay.
And you see my monthly statements and the detail I put in them. They are attached.
Okay, let me ask Ms. Belden this question.
Mm-hmm.
If by filing this lawsuit against Ms. Goodwin for 5,000, let me get the number, $5,349.82. And let's say that the court finds in your favor in that amount. Aren't you affecting the guarantee by doing so?
I'm sorry, pardon me, Your Honor.
Aren't you affecting the guarantee the guarantor by doing so? Where the principal debtor no longer has to pay the $10,000.
Well, they both signed on as so that's why I collected my total bill. My total bill.
In the letter I see, it says guarantor after the signature of Ms. Pintek.
That's why I filed two motions, or 2 claims, Your Honor. One is for yes. So I'm looking for
you're affecting the. I think you're affecting the ability of the guarantor by doing that. If you're successful in that suit, and if the defendant pays that amount, it looks like she's paid in full, and then the guarantor is stuck with the rest without the ability of getting any money from her daughter. Or you don't have the ability to get any more money from her daughter relative to the $10,000 amount.
That's why I'm trying to collect 2 judgments, reducing the amount I would take from each one for that $5,300. I would not go after each one for the full bill, correct?
Okay, so
I wanted 2 judgments of the $5,300 and
So you're talking about joint and several judgments?
Yes.
Okay, so as long as that someone, as long as either one pays the 5,000, whatever it is, 349.82 plus court costs, then the indebtedness is done as far as the 10,000. Is that right?
No, Your Honor. I'm sorry. That is not what I'm trying to accomplish here. What I'm trying to accomplish is that each would pay half of the bill. I did that to get into the small claims to avoid more costs. But
you're the guarantor. You're not looking for more than 5,000 from the principal debtor, so I don't see how you can look for more than $5,000. That same $5,000, though, from the principal debtor.
I'm looking for the same amount, but double. $5,349 from the.
Oh, I understand that. Yeah. I don't think you can do that.
Okay, I could move this to a district court matter, Your Honor.
Too late. Too late now.
Okay, I didn't want to do that. I need something that guarantees that I can get. I mean, under this judgment, they both are on the line for payment, or I'm sorry, under the retainer agreement, they're both on the line to pay my bill that they received monthly in itemized statements. There were no objections to. I'm looking for the full 10,700 roughly.
I understand. If I find in favor of you on the Goodwin case, then the amount that in that amount, then the amount that would be owned by the guarantor would be that $5,000 amount. Oh.
What if you found on the Hintech case first, and then no?
Well, it's easier to find the other ones. So I know how much the guarantor owes.
Mm-hmm.
Okay. So what I'm going to do is I'm going to consolidate these cases for purposes of judgment, since it's a guarantor situation. And I think that the case was very difficult. There was a good attorney on the other side who fights hard. Your attorney, in my mind, looking at the file, but that at her statements, fought hard as well. And at $250 an hour, the amount owed goes up quickly in this world. And if it's medical expenses, usually there's some kind of insurance that covers, but when it comes to legal expenses, there's not often that insurance that will pay.
Thanks, Credence and Mikey, for the super chat. Thank you.
No, this is my decision time. I've heard everything from both sides that I want to hear. So what I'm going to do is consolidate these cases, and I'm finding in favor of the plaintiff in these cases, and the amount of
Your Honor.
5,000.
Okay, Your Honor, quickly, is there a way that I could request that it be the full amount that I can claim under small claims of $6,500 plus the costs?
No, because you asked if I'm not going to let you change it at this time, because they already made some decisions based upon the amount. So,
okay.
Please, I really like it. No one to interrupt me while I tell you what I'm going to do, okay? Okay. So what I'm going to do is going to find in favor of the plaintiff on a joint and several basis against the defendant Haley Goodwin and the defendant Ramona Pentak in the amount of $5,349.82, plus court costs of $104.82 as to one case. So the total judgment would be the $5,349.82 plus $104.82. The total judgment would be $5,454.64, joint and several as to both defendants. So if one defendant pays for it, that's fine. If you pay for it part and parcel, as long as it's paid up to $5,454.64. So And I think based upon what I could see, I think your attorney did a good job for you. Okay. Divorce is very difficult. Custody is the worst of the worst because people are willing to pay whatever they need to pay for the safety of a child, both defendants. So if one defendant pays for it, that's fine. If you pay for it, part and parcel, as long as it's paid up to $5,454.64. So, and I think based upon what I could see, I think your attorney did a good job for you. Okay. Divorce is very difficult. Custody is the worst of the worst because people are willing to pay whatever they need to pay for the safety of a child. And it's just very difficult. There are two good attorneys on both sides, and they're both fight for their clients. And I see no, based upon looking at the file that I have, I see nothing other than good legal work. And I know that the attorney on the other side would be fighting hard as well, okay? But so I think the judgment is probably not going to make either side happy, but it's, you're paying about 50% of the attorney fees, and I think 100% was owed, but I'm doing it 50% because of the guarantor issue. So there'll be a joint and several judgment as to both of you in these consolidated cases in that amount. So the total amount that has to be paid is $5,454.64. And you'll each get a copy of the judgment in the consolidated cases, okay? And it's joint and several. So the plaintiff could go after one of you or both of you for that amount, which is half of what she requested, okay? So good luck to both sides. Thank you.
Thank you, Your Honor.
And that's how small claims does you. No one's ever happy when they leave small claims court. I think it's a rule that the judge has to come up with the exact verdict and judgment that will piss both sides off a lot. That's how small claims is. Oh, there's the mom and daughter. There they are. There they are. Liars. Liars. They lie. I don't know if she ever got custody of her daughter. Yes, they didn't show the custody trial, just the lawyer suing her Karen clients. That mom is delusional. She is 100% delusional about her daughter and her drug addiction. And she's going to blame the rest of the world and burn the rest of the world down until she finally comes to terms with the fact that her daughter lost her daughter because of drugs and not because of the rest of the world tampering with the evidence and the lawyer not doing this and the judge is not listening. No, ma'am, that's not true. It maybe a little bit, judges don't always listen. Lawyers don't always put in motions. And now the drug test, though, that's always accurate. People don't tamper with that. They just don't. Even friends of boyfriends, of girlfriends, of sisters, of cousins. All right. I know it was a long one. Thanks for coming out, guys. I really appreciate it. I'll see you all again soon. Bye.